Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. It's Thursday night, it's 5:15, so I am here. We're here doing this. Just like we do each and every week. Again, I'm John. I am the founder of the Consumer Warrior YouTube channel many years ago, and I am a consumer protection and a bankruptcy attorney in the state of Arizona. And what we do on the channel here each and every week is I answer questions. We talk about different topics related to debt collection, dealing with debt collection lawsuits, bankruptcy, wage garnishment, all those horrible things. And the way that we do this is if you have a question and you're on YouTube or you're on Facebook, go ahead and put the question either in the comments or the chat section. I'll put it up here on the screen and we'll talk about it. I am a licensed attorney in the state of Arizona. I do take cases in the state of Arizona, but I can't give legal advice here on YouTube. And you should never look for legal advice on YouTube. Anyway, if you need actual legal advice, you're in the state of Arizona, contact my attorney or my office down here at the number below, or you can contact an attorney in your particular state. That's my caveat to this. I'm not licensed anywhere else, and I don't know all the laws everywhere else. My goal here is just to point you to some resources, maybe get things, thinking about things as far as how you can deal with them and give you some possible solutions to them. So I'll put my information below. I also have over in the chat section and in the comments on Facebook, the Consumer Warrior University. That's a great resource, particularly for people who are representing themselves. I do a lot of in-depth tutorials, templates, forms, things like that. You can look through there. And then I also have a link to one of our sponsors of the channel, SoloSuit. SoloSuit uses technology in really cool ways to help consumers who are dealing particularly with debt collection lawsuits, as far as like drafting an answer and getting that submitted to the court. But they also help with things like debt verification letters and even debt settlement. So go ahead and click on that link, check out some of the things they offer. Great group of people and really cutting edge type stuff in the world of dealing with debt and debt collections. So I was looking through the comments today, and there's a few questions I thought that are fairly brief questions that we can just dive into while people are still getting here and putting their questions in. This one relates to junk debt buyers. Junk debt buyers, there's these companies that go and they purchase debts for pennies on the dollar, and then they sue people. And I can tell you how I got into kind of the debt buying world. Is, like I said, I do bankruptcy here in Arizona, and it used to be really all I did was bankruptcy. But I kept on noticing I was having people come into the office, and they were getting sued by Midland Credit or Portfolio Recovery or Unifund or one of the big debt buyers. And they were coming in because they wanted to file for bankruptcy because they didn't know what to do about this lawsuit. And, sometimes I was like, they're coming in, they got like a $4,500 lawsuit, really not a lot of other debt. And I'm like, I don't want to put you in a bankruptcy over $4,500. But, they're worried about wage garnishment, attorney's fees, all that kind of stuff. And so I started learning how to defend these. There's a group called the National Consumer Law Center. They provide materials not only for consumers, but for attorneys. I don't have my big books with me, but they create these big, thick books that are, they look like phone books, but they provide a lot of good information and case law to consumer attorneys like myself. I bought one of their books on debt collection lawsuits because I'm kind of doing some research, like how can we defend these cases, or what are some good ways to seek some type of resolution to them. And I was reading through there and I'm like, man, this is exactly what's wrong with these. They would say, this is wrong with this case. And then I would look at a case I had. I'm like, that's what's wrong with my case too. And so it went through, and that's how it started. And so I started blogging, particularly on Midland Funding, who they filed a lot of cases here in Arizona. And it was kind of funny for several years, no matter where you were on planet Earth, if you Googled Midland Funding, my law firm, skibalaw.com or consumerwarrior.com, would come up number one for Midland Funding. I would routinely get Midland Funding's mail. I'm actually forwarding back to them in their offices in San Diego and in Virginia saying, hey, I'm sorry, they sent this to me. Or I'd get people calling me and saying, why are you suing me? I don't even know who you are. And I'm like, I don't sue people. And they would think that I was Midland. So that's kind of how I got into it. But, this question is something I get a lot. The person put on the channel, he said, how do companies like Midland or Portfolio, Unifund, Resurgent, LVNV Funding, how do they buy our debt and then cry that we don't pay them? Don't companies take this money as a loss and report it to the IRS? So the debt buyer, so how it works is, let's say you have a credit card with Citi or Synchrony Bank, and 6 months of no payments, by law they're required to charge it off. I always say, one of the most controversial things I always say online that people just like give me all kinds of hate comments back is when I say, just because the debt is charged off doesn't mean they can't keep trying to collect on it. And people say, yes, if it's charged off, they're done. If it's charged off, all they're doing is counting as a loss on their books. It's an internal tax classification for them. They can still continue to try to collect on the debt. So, but what they're doing is, so they charge it off, and then a lot of these credit card companies, rather than handling the collections and lawsuits and all that by themselves, they will pool these up in a portfolio and they will sell them on the open market. They'll sell a big portfolio of old charged off credit cards, and they sell them at a discount to junk debt buyers. Junk debt buyers don't want to pay full price, obviously, because there's clearly already a history of not being paid on this. And so many junk debt buyers, they'll pay very little. There was an FTC study from Midland Funding a number of years ago. They found that they, on average, paid about 4 cents on the dollar for the cases. And some of them, or if they were outside the statute of limitations, they were selling it for less than a penny on the dollar. So they buy this big, portfolio of accounts for less, and then their business model is to sue people, get judgments against them, and garnish their wages or their bank accounts or lien their homes. And that's how they have decided to, chose to make a living in this world. So the original creditor, they do get some sort of tax benefit as far as the charge off, but the debt buyer does not. The debt buyer is just, they're saying, okay, we bought this debt and we're going to go sue on it. The problem that you often see with debt buyers is they don't pay a whole lot, and then they don't get a whole lot in return. They get a spreadsheet with a bunch of names and addresses and, contact information. The actual documents, or what they call media, they usually get very little. They might get what's called the charge-off statement. Sometimes you'll see the transfer documents. And then if they sue you and if you respond, 95% of people don't respond. And that's why I created Consumer Warrior University. That's what Solo sued. That's why because a lot of people don't respond because they don't know how to. But if you don't respond, they get a default and they don't have to prove anything. But if you do respond, then they will often go back and try to get additional documentation to be able to prove their case. So that's kind of how that whole debt buying works. There's a great book called Bad Paper. I'm trying to think. I think Halpern is the author's last name. It's a very interesting book to read because he dives into the debt buying world, and it's really crazy. I mean, there's some giant companies that handle this and they do everything like they should, but there's also some really shady, almost like mafia type groups that are doing debt buying, and it's kind of just a crazy world. So it's called Bad Paper. I'll put a link down in the notes if you want to check that out. All right. This person said, if I'm late 3 to 5 months on my bill, can I still file for bankruptcy? Yes. You don't have to be behind on your accounts. You don't have to be current on your accounts. The thing you want to be careful of is if an account gets too delinquent and they get a judgment, if they sue you and get a judgment, sometimes they can record that as a lien against real estate. There are mechanisms in a Chapter 7 to get rid of those liens, but it's usually a little easier and cleaner if you can just deal with it before it gets to that stage. But no, even if you're late, you don't have to be on time. A lot of people are contacting me in my law practice here in Arizona, and they're like, look, I'm totally current. I'm just seeing the writing on the wall. I'm not going to be able to make these payments anymore. And they'll even file the bankruptcy before they miss one payment, which helps credit score in the long run, because your credit score, it falls from wherever it's already at. If your credit score is already a 680 or a 700, yeah, you're going to lose 100 to 150 points on a Chapter 7 filing. But, if you're already at a 450 or 500, you're not going to fall as far. So this person said, in relation to debt collection lawsuits, who delivers the summons to your home? The police? What if you owe like $10,000 to 3 different cards? Will you get 3 different summons delivered? So generally the process in most jurisdictions is they file the lawsuit with the court, and then it's got to be served. You've got to be served with the documents so you get proper notice, so that starts the time frame for you to file your written response, which is called an answer, to the allegations in the complaint. Now, the summons, it kind of depends on where you're at. I know in Arizona, it's usually by private process server. These are private companies that are licensed to go get the documents, and they take them and they bring them over and drop them off. And then they file something called an affidavit or certificate of service that they keep inside that they file with the court. Arizona also has constables. I always think that's kind of funny. It sounds like something old English, the constable, the local constable can deliver it. But yeah, I mean, the sheriff's deputy can do it. And even certain situations, I think attorneys can do it. In most jurisdictions, you're going to see private process server, or maybe like a sheriff's deputy could do it, or a constable, somebody like that. And then they'll file their documentation with the court. So, all right, let's go ahead and jump into some of the questions. I looked at some of these questions were here nice and early. Let's go right here. Let's go to JW. It says, I have records unequivocally showing that they did not call or mail me any statements. Also, the affidavit of transfer is dated after they allegedly sent me the statements. Is this legal? And then I got your thing saying that the affidavit is dated January 4th, and the documents they sent in the response to the interrogatories are dated October 23rd. Okay, so you're on the right track. I will say this generally. When you get a debt buyer case, so in generally in most jurisdictions, how it works is if you file an answer, they have to provide you some sort of initial disclosure. So they're going to provide you some documents, at least the documents that they have. And it's important to go through those documents and just make sure everything lines up as it is. I go through them very carefully, and you would be surprised sometimes how sometimes there's significant mistakes. I remember one time they had submitted an affidavit from the original creditor, but it said, the name of the person said, I, John Doe, agree to, state that this account was here and it was transferred to the debt buyer on such and such a date. And then it had a signature, but the signature was of someone totally different than it was listed in the affidavit itself. So how that happens is a lot of these affidavits are robo-signed. They're either signed, they've literally done investigations, the Consumer Financial Protection Bureau was, or some of these big debt buyers would have people just sitting in rooms just signing affidavits, big stacks of them all day long. You can see how easy it would be for there to be problems with that. Because they're not taking the time to go through each case. They're just one after another. So, I mean, I found that issue alone got the case dismissed like that. That's a potential consumer finance or FDCPA violation. And they're going to have all kinds of trouble with something like that. So going through and doing what you're doing, if the affidavit where they're saying, hey, we assigned this account to, Synchrony Bank, saying we assigned it to LVMB Funding on such and such a date, and then you're starting to get even monthly statements directly from the original creditor after that, that's an indication that there's something going screwy there, that something didn't get transferred appropriately. So you're doing what you need to do there, and I think that's a good approach to go. So, all right, Mike and Jen says, I'm trying to prove a pattern of unlawful activity through the use of false or misleading affidavits. I've gone through 2 years of old court records and found suspicious affidavits. Some of these affidavits have dates when they were notarized, but no dates when they're actually signed. Others are signed in blue ink, which dates scribble underneath it in black ink. I'm in Utah, and there are no consumer attorneys here. My question is, does the affidavit need a date by the signature to show when it was signed, or is the date on the notary acceptable? The date on the notary is going to likely be acceptable. Sometimes there's purposely not something listed there because they want the notary to sign off exactly when it was signed. And that's the important thing to understand about a notarized document is the purpose of the notary, the notary public who is there. Their job is to, one, they can put people under oath to make sure that, saying, are you sure that everything you're saying and here's the truth? But usually they're really there to confirm the identity. The notary is going to look at your ID and to date it so that there's a verification of who you are and what date it was signed. So that should be sufficient in the notary if they, if that's squared away. I can tell you a good place to go look for things like that, again, is the Consumer Financial Protection Bureau. They have several consent orders that you'll find. You can just search for this on their website, and it often relates to things like that, like affidavits. If there's problems with it, a lot of times they've done this legwork for you. So there'll be a consent order where they'll sue. Like I know they did one against National Collegiate Student Loan Trust and their servicer, Transworld System Inc. I believe they did one against Portfolio Recovery Associates, where they outlined all the deficiencies in their affidavits and the problems they found. So if you have, you might want to go there and do a little bit of research and see if that's already been done in your particular case. Because if I've used those things before, where I've actually attached a copy of the Consumer Financial Protection Bureau's consent order and said, look at here, Judge, this company has a track record providing misleading statements in their affidavits. And so it may not discredit that particular affidavit completely, but it does create an impression that, hey, this company's not doing things always on the up and up. So, all right. Sal says, hi, John. I filed a motion to set aside voided judgment last week since I never got served. There's no certificate of service on file. How long does it take to get a response from the court? Thanks. So the way that the procedural rules work in a court hearing is, so there's these things called the rules of civil procedure in every state. And each court, like in Arizona, there's justice courts and there's superior courts. They each have their own rules of civil procedure. They're almost identical, but they are a little bit different. And they're going to give us the opposing side. So if you file a motion to set aside, you have to provide a copy to the creditor, the one who has the actual judgment. And in some jurisdictions, you have to serve them with it. And then they have to, once you get that to them, there's a period of time that they have to respond. In a lot of jurisdictions, it's 10 days. Sometimes it's 14 days. Sometimes they add mailing days. Sometimes they don't include weekends. So you need to look at the rules. It's usually around Rule 7 for motions. Rule 60 is usually when your motion is to set aside. It might be in there in your particular jurisdiction. So you got to take a look at that. That time period is going to have to expire before the court's going to grant it. So if you filed this just last week and there's a 14-day period for them to file a response, the court's not going to do anything until that time period expires, and then they'll issue a ruling sometime after that. But as I like to always say, you got to remember, when it comes to dealing with courts, it's their world. We just all work in it, and they'll get back to you when they get back to you. I once had a motion in bankruptcy court, and it was with the court pending ruling, fully briefed by both sides for over a year. And so, I mean, there was some kind of unique circumstances there, but not much I can do. So you just kind of wait. So, all right, let's see here. Travis family says, we live in Arizona. We sent a discovery and interrogatories in which they denied everything and stated they could not respond as there's no trial date set. What do we do next? This is for $800. So, the lawyer tricks when in written discovery, they file objections, objection, vague, objection, overly broad, objection is not likely to lead to discoverable evidence. They'll file these objections. Most of them are total BS. And so what you need to do is if they're just responding that way, if they're non-responsive, what you ought to do is go look at the rules again in your jurisdiction. A good place to find the rules, by the way, you can go to Google Scholar, or if you just Google rules, like Arizona Rules of Civil Procedure. Most states have it where it'll just pop up in a search, or you can go to Cornell's Law School, the Legal Information Institute. They have most jurisdictions. They have that information where you can look up the rules of civil procedure. So go look and see what the rule. It's usually around Rule 37, where they're going to be dealing with what we call motions to compel, because your remedy is to file a motion to compel with the court and saying, look, Judge, I'm asking for these things. But the reason why I'm telling you to look at the rules is often they have a meet and confer requirement, meaning that the parties actually either get on the phone. They used to require you to meet in person in a lot of jurisdictions, but get on the phone at least and say, hey, look, I need these. You need to tell me why you're not giving them. And then if they don't do it, then you can file a motion to compel and have them to turn them over. And most courts are going to require, in a contract case like this, they're going to require them to turn over that information. Derek says, went to court for a motion to compel discovery. Judge told me the lawyer has all the required documents and didn't need anything else. Filed a motion to arbitrate. Thoughts? Can she deny it? So you filed the motion to compel discovery. The judge told you the lawyer has all the required documents and didn't need anything else. Yeah, to me, if they're relevant to the case, I mean, the court should require them to turn it over. But if the court said no, I mean, it's, again, their world. The motion to arbitrate, can they deny it? They shouldn't deny it. If you have filed a motion to compel private arbitration and it states in there that they have, in the terms and conditions of the credit card, if it states that you're able to do it and it states that there is a sufficient, that you've done it sufficiently timely, then they should grant it. I always make sure to include a copy of that as an exhibit. I have a course on that. If you go over to the Consumer Warrior link that I have there in the section on a motion to compel, you need to include a copy of that. A good place to get the terms and conditions, if the creditor hasn't provided you that, is, again, the Consumer Financial Protection Bureau. They have a whole database of terms and conditions for credit cards. You got to make sure that's there. If there's not an arbitration clause, or if you don't have a copy of it, that's usually how it gets denied, is if you don't have all your paperwork together. So, all right, let's see right here. I still have possession of my IRS tax return check. What am I supposed to do with it? Chapter 7 was discharged in March of this year, Arizona. Okay, so in Arizona specifically, if you file for a Chapter 7 bankruptcy or Chapter 13, you usually have to turn over at least 1 year of your tax returns, and it's usually a portion of it. So what I would recommend is that you contact, if you had an attorney, and ask them what you should do with it, because then you can find out from the trustee. If you don't have an attorney, reach out to the trustee specifically. Depending on how much it is, and when you filed your bankruptcy and a number of other factors, they may say you can keep it, or they may say you need to turn it over so we can distribute it to your creditors. So I would make sure that you send that over there. So, all right, let's see. What a great question. How can you schedule a consultation if you're in the state of Arizona or you have an Arizona case? My phone number is down there at the bottom. Just give us a call. You can also, I'll put a link in the notes. I have a calendar thing where you can just set up an appointment. You can go to the website and do that too and set that up. But if you call that, they'll get you on my calendar. Again, it's only for Arizona residents. I can't do consultations for non-Arizona people because I'm not licensed anywhere else. So, all right, let's see here. Teresa says, I'm being sued for $1,600 credit card debt. I had to leave my career that I loved 5 years ago due to, I'm going to say that wrong, due to a health issue. I've lost everything when Lincoln Financial dropped me like a hot, I'm going to guess potato was the next word. Okay, so I don't know if there's a question there. I'm trying to see if it's there. Maybe it's down a little bit lower. There we go. Let me see. Sorry, I'm reading. I know this is bad video. I gotta get someone to help me cipher. There's a lot of comments today. So let's go with the Travis family. It says, have you heard of a motion to extend service? The court filed a notice of termination due to lack of service. So they filed a motion to extend service. It's been 90 days. Yes. If the creditor files a lawsuit in Arizona, they have 90 days to serve you. If it gets to the end of the 90-day period, the court's going to send out notice saying, hey, you got to get this done. And they can file a motion to extend it. And the courts will almost routinely, submit that. So, and the court will grant it. So that's something to be aware of. So, let's see right here. This one says, I had my 341 meeting. So the 341 meeting, if a bankruptcy case is filed about 4 to 6 weeks after, there's a meeting called the meeting of the creditors. The shorthand for it is 341. That's this bankruptcy code section that authorizes these meetings where a bankruptcy trustee will meet with you, put you under oath, and ask if what you've submitted is accurate. So it says, my 341 meeting ended and no bank representative was present, which is normal. I've been doing this now officially. October 24th of this year was 20 years that I've been a licensed attorney. I've been doing this for 20 years. The number of times a creditor has appeared and asked questions of my client, less than 10 times in 20 years. Very, very rare. And I do those meetings almost every day. So what is next to expect? So after the 341 meeting, you have to do a financial management course. It's another online video you have to watch. It's like usually an hour and a half long. And then if the trustee has any questions or any additional documents, they'll usually reach out to your attorney, or if you don't have an attorney, they'll reach out to you directly. Usually, though, from the date the meeting of creditors ends, 60 to 90 days later, the court will enter your discharge order, which is the order stating that it's over, that your case has been discharged and that your case will be done. So that's really what you're kind of on the downhill side of things as far as getting all that squared away. So this one says, I filed a motion to compel arbitration. It was denied because the court said I waited too long and waived my rights because I filed my answer first. I've seen this. I mean, what you need, again, it goes back to the motion. It goes back to the terms and conditions. Go look at it, because I can tell you a lot of arbitration clauses, they will state in them that either party could request arbitration as long as it's done before trial begins. If you have that kind of language in there, you can file a motion to reconsider on that and ask the court to reconsider it. If it's not in there, it may be a situation, particularly if the party's already gone through discovery, if there's been motion practice, if there's a trial date set, where the court may say, hey, you waive that by not bringing it up. I usually bring it up as well. I allege it as an affirmative defense in my answer. That way, there's really the waiver argument isn't such a big deal. Again, I have that in my templates, as you can see, but that's something I include there. So, all right, let's see if we got a couple more questions. Hey, Adam, thank you for supporting the channel. I appreciate that. So, all right, let's see here. Oklahoma Navy Federal Credit Union for a judgment in March for $6,700. The default date is November 2021. Judge vacated the judgment 2 weeks ago. I offered $2,000. I haven't heard from Navy Federal Credit Union's attorney. What is the reasonable amount NFCU can settle for? I offered $2,000 one-time cash lump sum. Settlement is, it always depends. There's a couple factors when you're trying to settle a debt. One is that they have a judgment. So the fact that you got that judgment set aside, they now have to start all over. It's not that the debt goes away, but it's that they've got to start all over if they want to get a judgment. So that puts you in a better negotiating position because they don't have their judgment already. They can't just start garnishing you or, going after your bank accounts. It matters whether usually it's an original creditor or a junk debt buyer. So if Navy Federal is the one who's bringing, if they still have it, if they haven't sold it, they're going to require something higher. Usually original creditors, you're looking anywhere from 40 to 70% of the total amount to get it done. And often if you can do it in a lump sum, you're going to get a better deal. If it's a junk debt buyer, I've seen it as low as like a 15%, right around to 35%. They don't have as much invested. Like I said, Midland pays 4 cents on the dollar. They don't have as much into it as the other creditors. So if it's original creditor, you're probably going to have to pay a little bit more than that. My guess is you're probably going to be somewhere between $2,500 and $3,500 to get it done. So Travis says, how do we fight a motion for summary judgment? The motion for summary judgment is kind of, they being the debt collectors and their attorneys, they know, particularly for self-represented people, this is the most difficult hurdle for them to get over. The motion for summary judgment is basically them saying, hey, judge, we don't need a trial. Just look at all this stuff and tell us if we win. And so and you have to file a response to it. And it's not like filing an answer. Like the answer is fairly straightforward. They have their set of allegations and you have to admit or deny. Summary judgment is totally different. You've got to come in and attack substantively what it is that they're trying to establish to show that they don't have sufficient evidence to win their case. And even if their motion for summary judgment is denied, all that means is the case is then going to go to trial. So how do you fight it? The main thing that you need to point out, so summary judgment should not be granted if there's a factual dispute between the parties. So summary judgment's appropriate, basically, if everybody agrees on all the facts, and then the judge just needs to apply the law. That's when you see summary judgment be granted. So what your job is to point out when there are factual disputes, particularly against junk debt buyers. You can raise the issue of, their ownership. have they proven that they actually own your account? Not that just that there were some transactions that happened between the parties, but have they used admissible evidence to show that your particular account was included? Have they shown damages? Have they shown specifically the dollar amount that they claim is owed? Or is it something that, they're just being conclusory as far as the amount that's owed? So that's really how you have to attack it. It can get tricky, particularly if it's for a lot of money. I usually recommend you need to probably talk to an attorney over something like that. You can look at my courses. I know that I do a deep dive into summary judgment because I know they don't want to do trial. Most debt collection firms, they have thousands of cases, relatively few attorneys. They can't go to trial on all of them. So you're going to get a summary judgment motion in almost every one of these debt collection cases. And so you need to make sure that, you're prepared for that. You for sure don't want to wait. If you're going to try to go through the arbitration route, you don't want to wait until summary judgment's filed. The judges will almost always say it's too late once they filed that with the court. So let's see here. I've got a couple. All right, let's see. Okay, I think we probably got about, I think that's about it. So, gosh, we've been going over a half an hour already. So, all right, I'm going to wrap things up for tonight. But hey, thanks for everybody for checking in, everybody supporting the channel. Again, go check out Solo Suit, sponsor of the channel here, as well as the Consumer Warrior templates, tutorials, all that. We also have a whole community in there. We have the university where people can, just like this, can talk amongst themselves in a kind of a more private setting about different strategies and approaches they use to deal with debt collection lawsuits. If you're in the state of Arizona, again, my number's right here below. My contact information will be below this video once we post it. And we do free consults for bankruptcy, debt collection lawsuits for those who are in the state of Arizona. Appreciate everybody checking in tonight, and we will catch you.